A lot quieter than last time. Good evening, ladies and gentlemen, and welcome to the 10th regular meeting of the Mount Laurel Township Zoning Board of Adjustment for the year 2025. The meeting is now called to order. If everyone can please rise for the Pledge of Allegiance and a moment of silence. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. If the secretary could please call the roll.
Mr. Dannenfelser is excused. Mr. Franciscone,
Here.
Mr. Gray,
Here.
Mr. Holmes,
Here.
Mr. Kramer,
Here.
Ms. Lopez is excused. Mr. Sharp,
Here.
Mr. Desai is excused. Ms. Trainer.
Here.
Thank you.
All right. Secretary, please read the open public meeting notice.
Notice of this meeting has been provided in accordance with the law by posting a copy of the annual notice on the bulletin board at Town Hall, filing a copy of the annual notice with the clerk of the Township of Mount Laurel, and emailing a copy of the annual notice to the Burlington County Times, Courier Post, and the Central Record. All of these postings, filings, and emails took place on January 22nd, 2025.
All right, ladies and gentlemen, there's the procedure of this board that every applicant is limited to 1.5 hours to present their cases, and that does include the public portion. If for any reason the application exceeds 1.5 hours, it will be continued to the next available meeting unless the board is polled and agrees to continue the public hearing. No application will be initiated after 10 p.m. If you have a cell phone, please silence it. If you are going to speak regarding any application, there is a sign-in sheet on the dais. Please, if you are talking as part of an application, make sure it's into a microphone. There is also agendas for tonight's meeting at the podium. And there's no announcements. Next, we have some minutes to adopt from the October 8th, 2025 meeting. Is there a motion?
So moved.
Motion by Mr. Franciscone. Is there a second?
Second.
Second by Mr. Sharp. All in favor?
Aye.
Any opposed? All right, next, we have some resolutions. Resolution R 2025-ZB22, Ronak and Ruchi Gore, ZB 25-C-14. Is there a motion?
So moved.
Motion by Mr. Franciscone. Is there a second?
Second.
Second by Mr. Sharp. All in favor?
Aye.
Any opposed? Next, Resolution R 2025-ZB23, MLS Operating, ZB 25-D-11. Is there a motion?
So moved.
Motion by Mr. Franciscone. Is there a second?
Second.
Second by Mr. Sharp. All in favor?
Aye.
Aye. Any opposed? All right, Jay.
Mr. Chairman, I'm sorry, real quick. I made a mistake. The minutes were from 11:05.
11-5, not 10-8.
Just for the record. Thank you.
11-5. You swear affirm the testimony you'll give this evening will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. If the secretary could please read the first application before the board.
First application is Todd Johnson. Zoning board number 25C16, 140 Fleetwood Ave, block 214, lot 2, in an R3 zone. The applicant's requesting a bulk variance from section 154-65E1 to allow an accessory building to be 16.6 feet high, where 12 feet is the maximum permitted height.
You are Mr. Johnson?
Yes, sir. Good evening.
Can you please raise your right hand? You swear affirm the testimony you'll give this evening will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right. So we have received your application. As far as I understand, you're actually going to remove 2 existing structures that are there and replace it with one that is larger.
Correct.
And you are looking for variances regarding the size and the height of the structure?
Just the height. It would be just the height.
Just the height. Just the height. Okay. I guess that was the question about it does qualify under the.
In my opinion, this is a pole barn.
Okay.
It meets the standards of pole barn, so the applicant would be asking for a variance of 154-65E1 to allow the pole barn to be 16 feet high when 12 feet is permitted.
Okay. All right. So at least with the other, I guess, question resolved about the size, only about the height. Can you tell us about why you need it, what it's for, what?
Yeah, so the main goal is eliminating the two other structures that are currently on the property. The height would be for the garage door opening. I do have a camper, I have other trailers. I want to combine everything and be indoors, eliminate it out of view. I mean, for the storage, and then, I mean, I don't know if on the plans you can see, it's a 1,200 square foot home. I have no current garage, other than the outbuildings that are there now, and a very low roof with very limited attic space. So the pole building would be the main storage for just anything with Christmas decorations, Halloween decorations, along with a lawn tractor I have. I want to get everything that's currently sitting outside, inside and out of view.
Jay, if this was a garage, would that height be an issue?
Yes.
It would still be an issue, yes.
Oh, okay.
So obviously, the thing you look at with this type of structures, what's the impact on the adjacent properties?
And your neighbor has a big, it's not necessarily a pole barn, but it's a garage or something. It's like 3-car,
My neighbor
Oh.
does have a 22-foot high garage,
22.
with 14-foot garage doors where a Mount Laurel school bus used to park.
Yeah, I'm sorry, what was that? What is the neighbor's stuff?
That's 22 feet high,
It approximately.
14-foot doors.
And so that is part of the residential property, that all those big structures behind it.
That would be my neighbor's residence.
Okay, so that's all whatever 38, what are you, 138, 136, 136. Okay, I get that is this is that
No.
pre-existing? or
No,
It got variances?
I would assume so. It
Yeah.
predates me.
Thank you.
Jay, is there concern about the height and any buffers back there, or?
The applicant has actually set the building 12 feet from the property lines. 6 is required, so he has doubled the distance from the adjacent property lines. My recommendation would be to add some buffer plantings adjacent to the building to reduce the visual impact on the adjacent property owners.
I think when we were looking at it, that the backside is already 22 foot is all covered with trees already. Is that
There
Correct.
are some existing trees in that area. And looking where the shed, sir, will any trees be removed to put this in?
Correct. The trees are gone now.
They're gone, so. So these are the area removed.
Okay.
Right.
So-
Oh, but some look like they're on the neighbor's like it's a very wooded property
It is,
surrounded.
it is.
So I'm trying to figure out where it is. I know where they're gonna want to place it. Where do you want the buffering trees?
I would put, I'm not concerned
Maybe
about the
west
rear
side?
because it's backing up to recreation fields and there's plenty of woods back there. But I'd like to see them between the proposed pole barn and the lot 3.
Which is 138, I think.
Address wise, yeah, it could be. Yes, I believe it would be.
You understand what he's saying? That
I understand what he's saying. I mean, there is a 6-foot fence there already. I would have to get 10, 12-foot tall trees put in. They go over top of the fence that's already there.
Yeah, the fence, you're only allowed 12 feet. And you're gonna be 16. So you're gonna be 10 feet above the fence.
Correct.
And with any variance, one of the concerns and one of the key issues is what's the impact on the adjacent property?
Jay, Mike.
And how you, I'm sorry, thank you. The impact on the adjacent properties and how to offset that. So in my opinion, at least, I think we put a row of evergreen trees in there, you'd be able to offset that impact of that, additional height. So there'd be no impact on the adjacent property owners. There are some arborvitaes, some Junipers virginianas, and some kind of cypress trees that will, grow maybe about 4 to 6 feet wide.
Okay.
And, they'll get to about 15 feet high, 16 feet high, that I think would fit in the area.
Okay.
The question is, planting these days has been very troublesome for me because anything I plant, deer eat. Any of the things you just mentioned survive deer and are deer as deer resistant as they can be.
It's inside the fence, right?
It's in a fence, but still, and they're in my backyard as well, through my fence. There's terms deer resistant, the best he can get.
Yeah,
Deer will eat anything if they're hungry enough.
they love arborvitae. You might as well just
Well,
be
they-
putting a pizza out.
Yeah, the arborvitae, but the junipers and the coniferous, they do tend to avoid.
And the green giant arborvitaes, they won't eat.
The green giant arborvitaes will get too wide. They get very, very tall, but they're going to get about 15 to even to 20 feet wide.
Wow.
And that's the concern. They only have 12 feet. And obviously you want to have a little room so that they're not right on top of the pole barn. So that's why I was thinking of those species. And I certainly can work with the applicant on that to address the concerns.
The property at 136, I mean, there is trees already there. If you were to stand where that proposed building is, you really can't see his garage already because there's trees blocking between our property lines. It would just be, I think placing arborvitaes or trees that are gonna grow along the fence line is just adding to trees that are already there.
I mean, I don't know. Are you looking? I'm looking at it on a satellite right now.
As am I, yes.
And he's been taken down since I'm looking at this picture, right? But his pole barn is going to be looking at some utility structure that already exists on that yard. You're never going to be able to see it from the neighbor's house because there's almost a forest between them. I assume they didn't take all that down, especially since most of it's on the neighbor's property. So I'm trying to figure out, like, we really need to worry about, like, it looks like there are still some trees there. I guess, are there still trees even after you took trees down?
To look at that property, he has planted rows of trees, multiple evergreens, as well as oaks that are
I don't know why it's,
Finally caught up.
I don't know why it said that. I didn't touch anything.
Okay.
Again, it's a recommendation. We're always looking to offset a variance. So if the board feels it's not necessary, that's certainly
No.
consider it.
Will there be electricity in this structure?
I don't have plans for it now. That would be later on down the road.
So no lights off of it? They're going to be pointing into neighbors' yards?
No, there would be no illumination going towards neighbors' residence or.
No plumbing, no electricity, no toilet.
It's not gonna have any type of occupancy, strictly for storage.
Are you going to pave the ground leading to it?
No, that would remain, well, I mean, sand, that's all I got in my backyard. I can't get grass to grow, but it would remain sand.
The other question I would ask is this just ensure it's not going to be used for commercial purposes.
Yeah, I have no intentions of commercial purposes. Already have a commercial property. If I want to work on cars or anything like that, I got out of working on car business. I don't plan on doing that.
That would just be a standard condition, I think, for us on this anyway. All right. Anyone else have a question? Anyone from the public want to speak about this application? Like I understand what Jay's saying, trying to offset the height of it, but there is, I think, what really seems to be a pretty good buffer
I'm not asking
between
for
it.
that
So I don't
condition.
think I'm really concerned about that condition. The other ones that we brought up, don't have lights facing your neighbors.
Not
no commercial
paving,
use,
not
the
commercial
paving,
use.
that kind of stuff, I think.
No occupancy.
No occupancy.
You getting all that?
I am. So if the member of the board were inclined to make a motion to adopt the application, I would recommend that the application include, the approval include a condition that the proposed pole barn not be used for commercial purposes, that if the applicant secures permits to bring electricity or plumbing to the building, it not be ever converted to habitable space or residential space.
And no exterior lights?
And no exterior lights facing neighboring property.
Understood?
You agree to that?
Yeah, I agree with that.
Go ahead.
I'll make a motion that we approve ZB 25C16 with the conditions just enumerated.
I'll second.
All right, motion by Mr. Franciscone, second by Mr. Sharp. Roll call, please.
Vice Chair Franciscone,
I approve.
Mr. Sharp,
I approve.
Ms. Schreiner. I approve. Mr. Kramer,
I approve.
Mr. Holmes,
I approve.
Chair Gray.
I approve.
Thank you.
All right, Secretary, could please read the next application?
Thank you.
I'll have a memo ready for you tomorrow. I'll send it to you and the zoning officer so you can apply for permits whenever you're ready.
Okay, so reapply for the zoning and the,
Did you already apply for zoning and were denied?
correct. Well,
Okay.
no, I was approved, but not for the height.
So you have to apply for
Yes.
this.
Okay.
Yes. Okay.
Right. Thank you.
All right, very good. All right, our next zoning board number 25C17 at 61 Abington Road. It's block 700.06 lot 1 in an R3 zone. The applicant's requesting a bulk variance from section 154-144 to allow a fence to be located 15 feet from the property line along Church Road where 30 feet is required.
Good evening.
All right, Mr. Ebling,
Yes.
can you please raise your right hand? You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Jay, this is one of those two frontages.
It's exactly what it is.
It's two front yard.
I did actually not go out to the site, but I did look at aerial photographs, looked at street views, et cetera. There's a lot of landscaping along that side of the property line. I just want to confirm that the fencing will be behind that landscaping.
That's correct.
Okay. So with the fencing behind the landscaping, I don't see any negative impacts to that fencing. I don't think it'll be in this site triangle or create any hindrance to visibility in the area. And I think with the existing landscaping, it will be screened.
Anyone have a question?
No, I do not.
Anyone from the public wish to speak about this application? All right, I'll close the public portion. At least from my review, there's no other charge or conditions, just.
Just the variance to allow that setback and to, I would, obviously we always put a condition in there to not to impede visibility.
Yeah,
That's just really so that if any future activity happens, it's covered.
and we haven't, part of the record that it's going to be inside the current vegetation and not disturb the buffer that's kind of already there.
For the record, would you agree, Mr. Ebling, that Church Road is a much busier road than Abington Road?
Oh, significantly.
And that your backyard will provide an element of safety, not only to your family, but to the public, because it'll prohibit people. from
Absolutely.
moving
Two
out.
small children and a dog. That's one of the reasons we like fencing.
Just wanted something about safety on the record.
Yes.
Anything else we need?
No.
All right, someone want to make a motion?
Mr. Chairman, I'll move that we approve zoning board 25-C-17 with the few comments just mentioned.
Motion by Mr. Franciscone. Is there a second?
I'll second.
Second by Mr. Sharp. Roll call, please.
Vice Chair Franciscone,
I approve.
Mr. Sharp,
I approve.
Ms. Schreiner. I approve. Mr. Kramer,
I agree.
Mr. Holmes,
I approve.
Chair Gray.
I approve.
Thank you. And same thing, I'll have a memo ready for you tomorrow morning. I'll email it. I'll give it to the zoning office. Did you already apply for permits?
I need to reapply to.
Was it just denied?
I believe it.
Okay, so you don't have to reapply. I'll give her the memo, let her know it was approved.
Affidavit, original copy.
Yeah, I need that. If you would, give it to Mike. You can take that.
You're like a bailiff now?
Thank you, sir. Thank you very much.
Yeah, we got a bailiff now.
Thank you.
I feel like we just need to have some banter now or something.
I can make a TV show. It's gonna be we gotta have our own show.
All right.
I'm good.
All right, next, Milby.
All right.
Does anyone want to read the?
Next application is Paul Milby, it's zoning board number 24C07 at 104 Phillips, block 408, 4.02 in an R3 zone. The applicant is seeking approval of a site plan pursuant to Whispering Woods versus Middletown Township, 220 New Jersey Supreme Court 161 Law Division 1987. The settlement plan requires certain bulk variances, including variances from limitations on structures permitted outside of the building envelope. side yard setback relief, fence height relief, and such other waivers and variances as may be required to implement the settlement plan. If approved, the settlement plan will modify the board's prior resolution R 2024-ZB12 and serve as a basis for the settlement of litigation in Superior Court.
All right, counsel, if we can have your
Read off the
appearance,
index.
please.
Sure. Good evening. My name is Sarah Warner with the law firm of Prime Tuvella Maselli, representing the applicant Paul Milby. Mr. Milby is the owner of property located at 104 Phillips Road. That's block 408, lot 4.02. The property consists of approximately 1/3 acres of land and is currently developed with a single-family residential dwelling together with related site improvements. As the board may recall, Mr. Milby appeared before the board. You want me to wait until he's done passing out?
Yeah, maybe.
Not a problem.
This is the same one that was already submitted.
This is the exhibit. Okay.
Oh,
Yeah, when I get to Mr. Dargy, we'll mark all the exhibits in. These are handout versions of a board he'll be presenting.
thank you, sir.
Well, as they use them, we'll mark.
Gotcha. Thank you.
Thank you.
All right.
So as the board may recall, Mr. Milby appeared before you in September of 2024 seeking variance relief in connection with various improvements that were already existing in the rear of his property. Amongst those, there was a paver patio area, there is a water slide, there's a shed, there's a sunken bar, and various other improvements. Those improvements, for those who may not recall, were constructed by Mr. Milby's predecessor in interest to the property. So when he purchased it, they were already there and came after the fact seeking the zoning relief. The application was granted in part with respect to certain variances, and some other variances were denied. The resolution memorializing these approvals and denials was adopted by the board in October of 2024. And subsequently, in November of 2024, our office, acting on behalf of Mr. Milby, filed an appeal of the denial. This has been pending in court since last November. We have had a few case management conferences, but I'm happy to report, as I'm sure you're already aware, Mr. Milby has been able to work with the board's professionals as well as with their neighbor, who I will touch on in a second, to come to an agreement that we believe resolves the main concerns that the board raised at last year's hearing. After considering all the, oh, I'm sorry, already went over that, getting ahead of myself. So as I stated, since the time the appeal was initiated, we have worked not only with the board's professionals, but with the owners of neighboring lot 4.01, which is owned by Steve and Bethany Creel. Mr. Creel is here this evening, as well as his counsel, Mr. Madden. After discussing with all parties the major concerns, the one most concerning aspect being a landscape buffer that the board wanted to see along the side of Mr. Milby's property, we came to an agreement with the Creels to provide a landscape buffer on their property via a license agreement that we are entering into with the Creels. This brings us back to why we're here this evening. Pursuant to the court's holding in Whispering Woods versus Middletown Township, 220 New Jersey Superior Court, 161 Law Division, 1987, the court found that the defendant planning board had, and I quote, the power to settle the pending litigation by tentatively agreeing to an amended plan subject to public presentation, why we're here this evening, a public hearing thereon, and a public vote. Our applicant's engineer, Rakesh Darji, is with us this evening, and he will be discussing the revisions that we made to the plan in detail. However, I want to provide you with a quick high-level overview of the key takeaways of this amended plan. First and foremost, as proposing a landscape buffer on the Creel's property. We're doing this by way of having officially amended the application to now not only include Mr. Milby's property, but to also include the Creel's property. Their attorney, Mr. Madden, submitted a letter of consent to this effect. So now any approval this board may grant is not only enforceable against Mr. Milby and his predecessors in interest to 4.02, it's also enforceable against the Creels and their predecessors in interest to the future owners of 4.01. As again mentioned, we will be walking you through the landscape improvements that are going to be proposed on the Creel property. I would note, Mr. Dargy will talk about this at more length. These landscape improvements have been worked out and discussed at length with the board's planner, Mr. Petrangelo. So he has seen everything that you're going to be seeing this evening. And again, as I mentioned, this is all going to be enforceable through a license agreement between both Mr. Milby and the Creels, a copy of which we will provide to the board as a condition of any approval. The second change you're going to see is that applicant is reducing the height of portions of the fence. This was a big sticking point at the initial hearing, as the fence in certain sections was in excess of 9 feet. We are not fully compliant. There are still a few minor areas where we're seeking variance relief for, but the most egregious areas are now being reduced to be compliant with zoning requirements. Third, the applicant is going to remove the existing shed on the property. One of the variances that was previously sought was for having 2 accessory structures, one being the shed and the other being the sunken bar. There were also some variances related to the setbacks for the shed. All of those variances are now going away by way of removal of the shed altogether. And fourth, the applicant is going to be removing approximately 260 square feet of pavers in the rear yard outside of the building footprint, thereby reducing the intensity of the previously sought variance in connection with same. So with all of that background in mind, I'm going to call Mr. Dargy at this time, if I could have him sworn in.
I could make one comment. And I appreciate the summary, and I think the summary touches on the improvements in the plan that speak to the concerns the board had. The value of the landscape buffer on the adjacent property speaks to the infringement on the side yard setback, right? There's a structure there that contains the water slide and the putting green, and it is at a 0 setback. So one of the additional things that this new plan shows is a 10-foot buffer, which essentially mitigates the fact that there's 0 setback on the side. That was the only other thing that I think your summary left out.
Thank you so much. So at this time, if I could have Mr. Dargy sworn in.
Raise your right hand. Do you swear or affirm the testimony about the Gill be the truth, the whole truth, and nothing but the truth?
I do.
Considering it's been over a year since the last hearing, I'll quickly have Mr. Dargy requalify himself.
I think
If it pleases the board.
I think he's still qualified.
he's
Oh,
qualified.
all right, we'll go with
Submitted
that.
as an expert before, we will maintain it.
Thank you. Appreciate that.
And we'll mark the exhibits as we go, including those that were handed out to you. So, Mr. Dargy, you obviously, just for purposes of the record, you're familiar with the prior application and were present at the previous hearing, having testified.
I am, and I was.
And you have been board's professionals in particular regarding the revisions that have been made to the plan.
Yes.
Could you please start by reintroducing the board with the plan that was previously presented at the September 2024 hearing?
Certainly. What I'll do.
I think there's
There's
one up
one-
here.
Oh, is there?
Yes.
You're going to need a
There you go.
microphone.
But you
Take the
gotta,
mic.
you
Yeah, just
gotta
grab
be on
that
the mic.
handheld.
Um, So the exhibit, I guess we'll call this
A1.
We'll start over at A1 for purposes of this resolution.
This is the plan of survey for the property. This was actually submitted to the board as part of the prior application. The applicant is proposed, it's basically a depict. It's pretty much exactly what Ms. Werner had just described. The applicant's, the prior owner of the property had constructed the swimming pool, slide, and another feature which, you know, is really part of the application is there's a retaining wall that the prior owner had constructed along a good portion, actually, I apologize, along this perimeter. There's a retaining wall, and upon which the fence is constructed, and that's what lends to the prior variance the applicant was seeking. The fence height, which the adjoining property owner grade, it's about spaces almost 9 feet. From the applicant's backyard, I'm sorry, from Mr. and Mrs. Milby's backyard, about 6 feet because of the retaining wall. Still didn't put it behind.
Is that mic getting picked up?
It's not, it just barely.
Oh,
So a little close.
Is that on?
how now?
That's better.
Yeah, that's better. I'm sorry, the
No.
mics are not great.
It's all right. It's probably best for all of us because if they were really good, I'd start singing. The The applicant had previously proposed, and I'll flip to A2, which is our current proposal, which also shows what we had proposed prior as well. So I'll just describe what we had previously.
Not doing anything.
Sorry.
I'm not touching it. on
It's
this.
haunted.
So just to get back to what I was saying, the applicant essentially proposed to remove a portion of the patio, which is proposed as part of this application as well, and also proposed to mitigate the impact of the stormwater runoff from the impervious surface. The applicant had proposed a rain garden, which actually captured the roof runoff from the existing dwelling, and then piped it to eventually where it eventually discharges.
And Mr. Dargy, just to clarify, we are still proposing that rain
We are.
garden, correct?
We are. So the applicant, and you want to go into what we're proposing now at this point?
Sure, if you want to.
So what the applicant is proposing now is in addition that we still are proposing the rain garden to capture the runoff from the rooftop to mitigate runoff to the backyard. We still are proposing to remove the 260 square feet of pavers. The applicant has now also proposed, and I believe that has already removed the shed to the back, which is 261 square feet as well. The applicant is also proposing to reduce the height of the fence along the where it exceeds the 6 foot height to be 6 feet, except in areas, the two areas I'll highlight. Within 17 feet of this rear section right here. And that's not because we don't want to. We are reducing that fence height, but for safety reasons, we can't reduce it such that it's exactly 6 feet when measured from the neighbor's property. It's going to be approximately 4 inches, up to 4 inches in excess. So we noted, and Jay made sure we noted, that this 17-foot section, the retaining wall is 30 to 34 inches in height. Therefore, that fence will not exceed 76 inches. It varies from 72 to 76 inches. The reason for that is because when you have a retaining wall with a height 30 inches, you have to have a 42-inch railing. So at that section, the retaining wall, the existing retaining wall, goes from a height of 30 to 34 inches. Therefore, that fence necessarily, for safety reasons, will have to be up to 76 inches in height. So it will exceed the fence height requirement by 4 inches.
Rakesh, that note just should have a minor revision, I noticed. It should say the overall height of the fence and wall will be not exceed 76.
I can
I
certainly
don't
make
want to
that.
run into a
Yep.
confusion. In the
You're 100% right. I'll make sure we make that change on the site plan exhibit. So that's a good point that Jay was just making. The heights that we're talking about are not as measured from Mr. and Mrs. Milby's backyard. They're from Mr. and Mrs. Creel's backyard. So that's taken into consideration the retaining wall height and the reduced fence height.
So just to clarify, it'll be 76 inches, including both the retaining
Correct.
wall and the fence.
Correct. The fence itself will be 42 inches in height, and then the retaining wall, which in that section exceeds 30 inches, therefore be taller than 72 inches, just in that section.
Now, there's another section which was a bigger sticking point with the board at the last hearing of the fence.
There is. If so at the top of the driveway, if you're viewing the driveway from Phillips Road, this beautiful backyard has a slide. It's not one of those curly slides that most people get. This is one of those long resort kind of slides. There's a pavered patio deck that's built there, which you have to climb up necessarily to get slide. It's not terribly high because the grade of the property actually naturally drops towards the back. So this height of this paver is about 40 to 46 inches in height there. So in order to provide some privacy, the prior owner actually constructed a 2-panel fence there. So it exceeded.
I think it was in
In excess of.
It was, I think it was almost a 6-foot fence on top of the retaining wall.
Definitely over 10.
Mhm.
So if you drive by, and look down Mr. and Mrs. Milby's driveway, see a 16-foot section that was about 10 to 12 feet tall.
So I think at this point, it'd be good to introduce Exhibit A3. We'll mark this A3. We passed out a rendering. This is a crude rendering, but nonetheless, I think it's more visually appealing than the large white fence. I will let Mr. Dargy testify as to what's going on now.
So what the applicant proposes to do is, once again, what the applicant proposes to do is reduce that fence height. So it is 6 feet. So the fence actually at the top of the driveway, as you can see in the illustration, will be cut, and it will be no taller than 6 feet when measured from the driveway. So the retaining wall is 40 to 46 inches in height, and then the fence on top of that will be the balance of the 6 feet. And again, however, for safety purposes, because you do have this platform that's made of this paper and retaining walls to utilize the slide, the applicant does require a railing of 42 inches in height to meet again the fall hazard code. So the applicant will construct a railing that's similar to the existing railings that they have in the around the slide. There's railings along these two sides. They don't have a railing right now along this side because of the fence. So what they'll do is they'll construct that railing, and you can see in the render in A3 what that railing is going to look like. It's going to stick about 10 to 12 inches above the fence. It's constructed behind the fence, so it'll be 42 inches in height. But from the street, you'll only see the top part of the railing, the top 10 to 12 inches. And so that rendering gives you an idea of what that looks like. So that's what the applicant's proposing there. Again, to mitigate the impact, like Ms. Warner had stated, to mitigate the impact of the retaining wall and the minor, fence height exceedance, the applicant is proposing to landscape their neighbor's backyard with landscaping that we've reviewed with Mr. Petrangelo and actually with his in conjunction with his advice. So that's basically what we're proposing along that area. The applicant, and we are still proposing to remove the 260 square feet of pavers, still removing or have already removed the shed, and we'll propose, we will construct the rain garden to attenuate the runoff from the rooftop.
Mr. Dargy, I want to quickly touch on the variances. I know they were stated at the top of the application, but if you could just correct me if
Certainly.
I'm wrong. The first is to allow the fence to exceed 6 feet in certain areas, which you just went over, and that one area is by about 4 inches, correct?
Right. Correct.
The next variance, as Mr. Campbell brought up, is for that 0-foot setback from the patio. That's actually that little retaining wall
Yeah,
area.
just want to clarify that real quick. And we are asking for the 0-foot setback. That's because there's a retaining wall along the property line, and the retaining wall counts as a structure. So that's where the 0-foot setback comes from. The patio itself, however, up here is going to be 9.5 feet from the property line. There is a walkway from the patio towards the slide here, which at its closest point comes to within 1.5 feet of the property line, because it does have a little bit of a undulation to it. So as it curves around, it gets to be about 1.5 feet here from the property line.
And to offset that, and I will have Mr. Creel's attorney speak to this a little bit more in a moment. That is why, again, we're proposing that 10 feet of landscaping on the Creel's property on the opposite side of the fence, correct?
That's correct.
Okay, and then lastly, we are still seeking the variance, albeit reduced variance as compared to last time, for the total allowable impervious coverage related to patios and terraces outside of the building envelope.
That's correct. So the allowable for impervious coverage associated with patios is 250 square feet outside of the building envelope. So the building envelope, there's the rear you may be able to follow it along on the exhibit I've handed out. There's the rear property line or rear setback line there, and then you also have side setback lines along there. They're very faint. So this impervious coverage that's outside of that, by your code, is permitted to be 250 square feet. After we remove this 260 square feet, the applicant will be left with 879 square feet. So we are asking for the variance to exceed that 250 square feet.
Now, just quickly, just want to point out that the ordinance requirement specifically refers to patios and terraces. So the shed that has now been removed was an additional 261 on top of
That's
the
correct.
other 260 that we're removing, correct?
That's correct.
With that, I don't have anything else from Mr. Dargy. I would like to have Mr. Madden come up briefly on behalf of his client to discuss the landscaping on his client's property. But if you would like to question Mr. Dargy first, by all means.
So looking at the proposed conditions list that we have, 2C says our prior variance to allow 200 feet in additional to the 250 remains. And there's in 3C, it says we're going to be to allow 588 square feet on top of the 250.
So the 588, I think, Mr. Campbell, I sent you an email correcting this. It should be that 879. It was a
It was a mathematical error on my part.
mathematical error with the wording, just because of that shed didn't count into the previous equation, which we thought it did.
But I think Mr. Gray's point is, in the proposed conditions, we were reaffirming the variance that you previously received to allow you to go to 450, 200 over the
Mhm.
250. If I understand Mr. Gray's point, and I agree, we should clarify the conditions so that the prior variance granted allowing you 200 over the 250 is now increased to allow you, if the board approves it,
It's roughly
879.
879 total, which is
879
total.
total. So minus the 250, it's X amount over the 250.
629.
That's
Yeah.
correct.
So I'll amend the conditions if the board approves the application to reflect that, either by changing C or changing 3C.
Thank you. Does the board have any further questions for Mr. Dargy at this time?
If I want to confirm, so I'm understanding,
No,
the
go ahead.
879 is the total, correct?
879 is the total of
Outside of the building
outside of the
envelope.
building envelope.
Okay, but it's not 879 plus 250.
No.
That's correct.
No.
It's 879.
Yes,
Good. That's
that's
what I wanted to
correct.
make sure.
Yep.
Thank you.
The relief is for 629.
That's
Yes.
correct. 629 above the 250.
Unless there's any objection, if I could have Mr. Madden come up at this time?
Let me just see if
It's on here. We merged it into the. Yeah, sorry. Yeah. Just for making it easier. So we put it all on one sheet. Yes. You can see, I think we have the small
I'm
version.
under 100%.
Are you okay if I go to Mr. Madden now? Or are there any further questions for Mr. Dargy?
Sure,
All right.
Mr. Madden.
I don't have to swear him in as he's an attorney, nor do I have to qualify him, but I'll say that he is co-counsel with me on this application. to the extent that-
just ask him to place an appearance.
Evening, everybody. My name is Matt Madden. I'm from the law firm of Madden and Madden. I'm here tonight representing Stephen and Bethany Creel. They're the owners of 100 Phillips Road, Block 408, Lot 4.01, which
Are
is,
we getting it?
you picking me up? Or you need me on the big mic?
If it's not too much
No.
to ask. Sorry.
Whatever you need. Again, Matthew Madden. Is this even on? Turn
It
this
is.
off?
The little green, you can see the little green.
It
thing
just
more
might be
than you
too
can
low
hear
for your
you.
mouth.
Okay.
It might just be pull it out. Right, there you go.
All right.
Yeah, there you go.
Again, Matthew Madden from the law firm of Madden and Madden, here tonight representing Stephen and Bethany Creels, the owners of 100 Phillips Road, Block 408, Lot 4.01, which is located adjacent to the Milby's property. If you're looking at it from the street, we're directly to the right. As part of the Milby's and the board's amicable resolution of the pending lawsuit, my clients have agreed to allow some landscaping to be installed on their property adjacent to the fence, which exceeded the maximum height allowance and needed a variance as a means of buffering that fence, and as one of your professionals indicated, to create some sort of a buffer distance for the setback. My clients have consented to that being installed and being included in this application for the sole purpose of allowing that landscaping to be installed, and we'll be memorializing that in a license agreement to that effect. I'm not here to object to the application or upset the apple cart as far as any settlement's concerned. The primary purpose of my appearance was really to observe and ensure that the plan that we agreed to, the landscaping plan, is what is ultimately approved by this board and what's being presented to this board. And it appears that it is This is a merged exhibit I have not seen yet, frankly. The landscaping plan I saw was prepared by ERI, bearing a most recent revision date of November 3rd, 2025. So provided that's consistent with this, we have no objection.
I would suggest you take a chance to review it, because if we're marking and saying it's this one, if that's
you go.
not what your clients agreed to.
That is, we
The-
both have it.
The November 3rd,
That's the hearing exhibit, that's the landscape.
Is it a four?
Well,
A4, yes.
I'm going to complete what I came here to say. If you wouldn't mind taking a 5-minute recess thereafter, so my
I
client.
have no
could review
problem. I
that.
want to make sure it's right, so.
Okay. So the primary purpose of my appearance, I mentioned, was to ensure the plan we agreed to is what's ultimately approved, and really ensure that no obligations are imposed on my client beyond what we've agreed to do, and that's allowing landscaping, doing that pursuant to a license agreement, and ensuring that that landscaping is what we agreed to. Your solicitor was kind enough to provide me with some draft conditions of approval that would be included in any resolution. I had just requested that they leave out any specificities as far as the obligations for maintenance. One or the other party is going to have to maintain this. That has to be worked out. In all likelihood, it's going to be my client, so he doesn't have somebody appearing on his property, but there will probably be some provisos in there to the extent, a $5,000 tree has to be replaced. We don't want to do that. So council's indicated they're agreeable to working out those terms, so we're not anticipating any problems there.
Yeah, just to clarify, we're not stating that we don't want maintenance obligations in the resolution. Obviously, we do. We just don't want to stick it on one party in the resolution. We want it to be, someone has to do it, and then we work out amongst ourselves. But above and beyond that, Mr. Milby will be posting a performance and maintenance bond with respect to the landscaping.
Yeah, and of course, there's going to be an obligation to maintain that landscaping, and if it's not maintained, the township's going to have a right to issue an NOV against either my client or the Milbys. And as Ms. Warner indicated, there's going to be a maintenance plan, bond in effect to ensure that that's done. With all that being said, my clients agree to that landscaping, provided after the recess, we come in and say it's accurate in accordance with the plan, and appreciate the opportunity to be heard by the board. Happy to answer any questions.
How does the license agreement stay with the properties? Normally, in circumstances like this, we have an easement or something else that actually attaches to.
So we are going to negotiate it amongst ourselves, but then we will provide a copy as a condition of the resolution of approval. And as this board's aware, once you approve something, it's on the record for the properties, and any violation, AKA if either party fails to maintain it, regardless of whose responsibility it is enforceable against the property, not the individual. So whether that's the current owners of lots 4.01 and 4.02 or a future owner. To this end, I just remind the board that the reason we're here in the first place is because when my client, Mr. Bilby, went to purchase the property, violations were noted and they were enforceable against the property, not against the prior owner.
And he bought it knowing that there was all those violations, took the risk to.
And that's correct, but it was
So that
part
wasn't if
of.
He got it and didn't know it was.
It's part of the closing process. Mount Laurel Township requires you to get a CO, and as part of that CO, they inspect the property to check for zoning violations. They confirm what zoning requirements are against the property. Title companies by law routinely look for that. So any future property owner that would purchase this property would understand as part of the CO the approvals that have been granted in connection with their property. That was the nexus of us amending the application so that it could be enforceable against 4.01.
Questions? All right, so I think that we'll take that 5 minutes, Mr. Madden, be able to review this with his client to make sure this is the terms and conditions they were looking at or plan that they were looking at. And we'll come back. So.
Thank you.
Break for 5 minutes. All right, we just took a break. Mr. Madden, do you have a chance to review that plan?
I did have a chance to review the plan. We're okay with it. We're in agreement with it. There was one quirk in that species schedule that was previously on a landscaping plan was not included in this merged exhibit. I understand council's represented that that landscaping plan that we previously approved is going to be incorporated into their settlement agreement as far as the court is concerned.
So
Yeah. Just to clarify, we had previously submitted and what the board had was a site plan exhibit, which showed the revisions on the Milby property, and a landscaping exhibit, which showed the landscaping improvements on the Creel property. Those are what we're relying on. The hearing exhibit you see tonight was simply for visual purposes, merging those two plans. But the two individual documents, at least from my perspective, Mr. Campbell, is what will be appended to any consent or settlement order with the court.
we could mark the landscape exhibit as A4 for the purpose of the
That's
record?
fine. Yep.
That's the ERI dated November 3rd. as
Yes.
said later.
Yep.
And I just want to clarify, the landscape schedule on that November 3rd plan is acceptable.
Yes.
Okay.
And we will also be, just again to clarify, as Mr. Gargi stated on the record, he will make the revision to the site plan exhibit that Mr. Petrangelo indicated about the overall height of the fence and retaining wall. So with that, unless Mr. Madden has anything else,
Nothing. Thank you very much.
I don't have any further witnesses. I'm not going to belabor the application anymore with a closing statement because I think the board is more than familiar at this point. But I do want to thank you for your time.
So while Mr. Madden is close to the mic and while you're here, the proposed conditions, I don't want to read all of them, but it does state, just to be clear, that in the event that Mr. Creel or the Creel family or the Milby family fail to maintain it, then the township can seek to enforce it as if it would enforce any other zoning approval.
Yes. And then we
That's
will work
understood.
out amongst ourselves pursuant to our license agreement.
Yeah, you should handle it yourself before it gets to us.
Yep, absolutely.
Thank you. I don't have any other questions.
All right. I do think it's worthwhile to make sure we have everything that was listed as part of the agreement actually placed on the record.
I would suggest, if you want to do that as potential conditions, but to open it up to the public first.
Well, I think
Unless you want to do a
we
different
should
order.
Go with what these are and then give the public. a
Okay.
chance. Is there anyone from the public here that wishes to speak about this application? All right, we don't have any. If someone does come in, address it, but at least as far as
Like me to review the conditions with the board?
yeah, I was going to say either you do it or counsel for applicant go through them. We'll make sure that we've addressed all these outstanding things.
So, Mr. Chairman, members of the board, as Mr. Madden indicated, I had circulated a proposed series of conditions, because if the board was going to approve this, I wanted to make sure that we weren't imposing conditions which the parties wouldn't agree to, and that we'd wind up back in court. So the conditions that I proposed, I'll summarize them. Number one is that the applicant agrees to accept and abide by the terms of the conditions of the prior board resolution R 2024 ZB 12, except as expressly modified by the board pursuant to these proceedings, which will be memorialized in a resolution adopted by the board next month. The variances previously granted by the board and memorialized in R 2024 ZB 12 are affirmed. I list them. One being an ordinance to allow a shed of 291 square feet. The applicant has indicated they're removing the shed. The second variance was to allow the shed to be set back 5.9 feet from the rear yard property line. Again, the applicant has indicated they're removing the shed. The third variance the board granted last year was a variance to allow 450 square feet of impervious coverage, meaning 200 over the permitted 250. As we indicated before, we're going to revise that if the board approves the application, so that the total square footage of impervious coverage outside the building area would be 879, which is a variance of 629 square feet over the permitted 250 square feet. Additional variances that would be granted if the board approves the settlement plan would be a variance from 154-64A, permit structures such as patios and terraces to be set back 0 feet from the property line instead of 10 feet. We've discussed that, and that variance is mitigated by the installation of the landscape buffer. The second condition is a variance from 15-167, the second variance now being granted would be from 15464A to permit fences to exceed 6 feet in height, consistent with the testimony today and the plan, and is noted in one section, that fence, a 17-foot section, that fence will now be as much as 4 feet high, 4 inches greater than the 6-foot limit. I'm sorry. I've been corrected. What's that, Susanna?
It's from 144.
Sorry, 1 foot, yes. And then finally, the variance to allow impervious coverage, which we've discussed, of 879 square feet, which is, again, the 629 over the 250. The applicant agrees to install a rain garden on the property where indicated on the plans. The rain garden will be subject to the township standard form of recorded covenant requiring the property owner to maintain the rain garden. I'll provide the applicant's counsel with a copy of that. It's the township standard form and requires the applicant to maintain it pursuant to township standards. The applicant shall cause the removal of 260 square feet of pavers from the backyard to reduce the impervious coverage. This is also indicated on the settlement site plan. Mr. Milby shall cause to be planted and installed landscape improvement as indicated on 100 Phillips, also as indicated on the settlement plans landscape exhibit. That's A4. Once planted and installed, the landscape improvements on 100 Phillips shall be maintained. In the event that the Creel or Milby families fail to maintain the landscape improvements on 100 Phillips, the township shall have all rights available to it at law or in equity, including but not limited to issuing notices of violation to either or both property owners for failure to comply with the express terms of this approval, in accordance with paragraph 16 below, or calling upon a maintenance bond, which shall be posted by Mr. Milby, as set forth in paragraph 9 below. Paragraph 9. Mr. Milby shall post a performance bond and a maintenance bond with the township to secure the installation and maintenance of the landscape improvements on 100 Phillips. Bond shall be in an amount approved by the board's professional staff, shall be subject to terms and conditions customarily imposed by the township for such bonds. Mr. Milby the next condition would be Mr. Milby will install the rain garden as proposed during the original hearing and discussed in the engineering review letters from the original application. I have incorrectly circulated a condition that says Mr. Milby will record a covenant or other instrument on title that requires the owner of 104. Sorry, that's correct. Mr. Milby will record a covenant or other instrument on the title that requires the owner of 104 Phillips to maintain the rain garden. This improvement or instrument shall be approved by the board's professionals. Again, that's going to be the same form that the township ordinarily uses. The applicant shall apply for and obtain any and all required permits, certificates, approvals, variances, license related to the proposed use and construction, and shall pass any and all required inspections related to the use and construction of the improvements. Mr. Milby shall pay all required fees and shall comply. Mr. Milby shall pay all required fees and shall comply with all federal, state, and township laws and requirements, including without limitation all applicable provisions of the township's code relating to this application. The property taxes shall be paid to date. Mr. Milby shall reimburse the township for all costs, including but not limited to attorney's fees associated with the litigation and the approval of the settlement plans. And the conditions of this approval may be enforced by the township and the township zoning officer as zoning violations pursuant to a so-called stop work order or injunctive relief or in any other manner as may be permitted by law in equity or under the code. Those are the conditions that we had circulated previously between Mr. Milby's counsel and Mr. Creel's counsel, and I had provided a copy to the board and Mr. Petrangelo prior to tonight's.
We confirm agreement with these conditions as presented before the board this evening, having previously reviewed them and agreeing to the amendments made on the record.
All right, just a couple questions. The agreement says either or both are required to maintain, but it's clearly going to be Milby's responsibility to plant and install this?
Yes, we are planting it and installing it. That's a condition of approval. It's going to be part of the license agreement. And Mr. Milby, to that end, will be the sole party hosting and maintaining our performance and maintenance bond.
I think the language in the condition is Mr. Milby will cause it to occur. And that gives them the flexibility to accomplish that.
Yeah.
But it's Mr. Milby that's got to cause it.
Yeah.
Whether it's him out there with a shovel or,
We will be hiring landscapers to do it, but yes, Mr. Melby will be the driving force behind it.
Second, I guess it's paragraph 16. When it says all township costs, that's planner, engineer, and costs too.
yes.
Um,
You agree?
Yes.
Yes. Oops, sorry. Wrong person.
Doesn't specifically say in here, but if it's approved, then the litigation's dismissed with prejudice.
With the caveat that the court would retain jurisdiction to enforce it,
Yes.
but yes.
And I'll put on the record that we have been in contact with the court this week. We currently have a case management conference scheduled for January 7th, I believe. But they've asked us to report back as to how this evening's hearing turns out. So assuming the board were to approve this evening, we would work out in advance of that case management conference, either a revised consent order dismissing with them retaining the right to enforce or whatever other form of document the court wishes to see of us.
And procedurally, if the board were to approve the settlement plan tonight, at your January meeting, I would have a resolution prepared for you to review in advance, and you would adopt that resolution at that meeting memorializing settlement.
Anybody have any questions? Double check now that we did that. Anyone from the public? No. Okay. All right. Anyone like to motion regarding the application?
Can we do it just like, what's coming through?
Here.
And we're accepting the agreement, right? A resolution to accept the agreement?
Yeah, we can make a motion to approve the settlement plan.
Approve the settlement.
All right, Mr. Chair, I'll make a motion. Approve the settlement plan related to ZB 24C07 with the conditions enumerated by our council.
I'll second.
All right, motion by Mr. Franciscone, second by Mr. Sharp. Roll call, please.
Vice Chair Franciscone,
I approve.
Mr. Sharp,
I approve.
Ms. Triner,
I approve.
Mr. Kramer,
I agree.
Mr. Holmes,
I approve.
Chair Gray.
I agree.
Thank you.
Thank you very much for your time this evening, Mr. Campbell, Mr. Petrangelo. Thank you for all your help. Be in touch. We will get you the revised exhibit. Okay.
Thank you to Mr. Madden. Thank you. Thank you. Thank you, Mr. Creel.
I'm
All
sorry,
right,
could you?
only other thing for the board members in the Dropbox is draft meeting schedule and stuff for reorg for the January meeting. At that meeting is when we adopt the schedule. So take a look at the dates. If there's any conflicts with something that we need to address or move, let us know. Otherwise, our next meeting isn't until January 14th. So motion
Right.
to adjourn.
Before the motion, at the January meeting, I think on the agenda will be the adoption of the report. So it's
The
worth,
findings and fact is in the Dropbox too. Yep.
yep, and if there are recommendations that the board,
Will we be adopting that on the 14th?
Yes.
Yes.
Okay,
we should
did
be
we
ready.
have, between then, or is there any suggestions we want to make? I'm sorry.
that's where I was going.
Yeah, because if so, we need to discuss them and get them in there before the
Yes.
14th.
Well, I think what we did last year was we adopted the report summarizing your activity in January, and I think we made recommendations and forwarded them in
No,
February.
I thought they were part and parcel the same thing.
I don't,
I think we did them separately.
and
In the past,
Either way.
long time ago, it was always one report.
it was the first time that I recall we bifurcated it. But I think the MLUL says that you can do it, you must do it once a year, but doesn't say you can't do it more than once a year. Right? So that's
Correct.
how,
Yeah.
so that's why, I think that's how we rationalized bifurcating. So if we want to talk about recommendations now, we can do that, or we can do it in January.
I don't know that necessarily any issues particularly came up this year that we had to go back and say, hey, take a look at this. Because council
We
already,
seem to have a lot of those fences with two roads.
Yeah, I was thinking about that. The only problem is with sight lines and landscaping buffer and all that, it's not easy to write into the ordinance something that works for all the situations, even though we approve almost all of them.
Yes, but it's better to have them, frankly, in the ordinance have the requirement, and have the applicant come to you and evaluate each one, as opposed to trying to adjust the ordinance and cover, frankly, the bases we've covered each time. Without actually physically seeing it, it's kind of difficult to, make an opinion as to what would be a negative impact on the adjacent properties.
Yeah, the only other thing that kind of came up as a question was our definition of a pole barn.
The definition is not uncommon. The definition has a statement that says generally used for, I believe, agricultural purposes, which is true. That is kind of the accepted definition. It doesn't mean only, it's just generally. And that's pretty much the only place you really get pole barns. Pole barns don't have foundations, they don't have same structures as barns, so. Bless you.
I think our definition says a farm building. I think it's the first 3 words of,
All right, unless anyone has something else, I mean,
we took out the agricultural use thing. We left the.
It
a
said
farm
generally for
building.
farm, something out of.
Yeah.
Yeah, I mean, I haven't thought about it. I don't know if we made any notes this year on it. I don't remember.
I don't think we really had like.
I don't know if we've asked for other things in the past that haven't been adopted. To be honest, I don't remember. I think there are.
I think that they,
So we want to re-recommend those things.
I think that anything that.
So
we
it has to be
actually-
based on what we've done in the year. Like if we've,
Yeah, I think anything that we've put forth, they already did make some revisions. I don't know.
I know they made some, but I don't remember I don't have in front of me last year's recommendations.
All right,
and I
well,
don't know which one.
Susanna can circulate last year's, and if anyone has anything.
Hey, can you
just
comment
submit it.
if there, what if any were addressed this past year?
I mean, I can tell you what ordinances have changed.
Yeah.
And I believe there were changes made at the beginning of the year to address your comments, if I recall properly.
We changed industrial signs based on you guys' comments. Adult daycare, placements of adult daycare.
Yeah, adult daycare's in that whatever zone.
Yeah.
All right, without anything else, I'll do a motion to adjourn. Is there a second?
Second.
Second, Mr. Sharp, all in favor?
Aye.
Thank you very much.
Merry Christmas, everyone. Happy holidays.
Yeah, happy holidays.
Holidays, Merry